Hi, my name is Barry Weber, and I'm an attorney and CPA in the Fresno, California area. And the purpose of this webinar is to introduce you to revocable living trusts. This is only an introduction to the basic concepts, and it's not intended to be legal advice or form an attorney-client relationship with you. So what is a revocable living trust? Well, as the name implies, it's revocable. The trust can be modified or revoked at any time before the settlor, and I'll define that term in a minute, dies or becomes incapacitated. It's living in that it's created during the settlor's lifetime, and you'll also hear it referred to as an inter vivos trust. So the key parties to the trust are the settlor, who is also called the testator or grantor. That's the person that contributes property to the trust. The trustee is the person appointed by the grantor to have power over the trust assets. And it's usually the settlor in the case of a revocable living trust. The successor trustee is also appointed by the trustee, who in most cases is the grantor, to take over when the original trustee dies or becomes incapacitated. The trust property, of course, or the assets in the trust is also called the trust principal or the corpus, and that's the property that you transfer to trust. The trust document is the declaration of a trust that is a written agreement and contains all the terms of the trust. The beneficiary or beneficiaries are the parties who get the trust property when the settlor dies. Now you'll hear the term certification of trust, and this is not a trust document. It is simply a shorthand version of what's in the trust document to give to a financial institution or other interested party that needs to know. The key features of a revocable living trust: the settlor is still treated as owning all of the property contributed to the revocable living trust. The settlor is taxable on all income earned by the assets of the trust, and no trust income tax return is required to be filed while the trust is still revocable. So the assets are treated just as if no trust existed. All the tax consequences of transactions within the trust are reported on the settlor's individual 1040 tax return. Now, a revocable living trust does not protect your assets from creditors. The assets contributed to a revocable living trust are fully available to the creditors while the settlor is alive. There are certain types of irrevocable trusts to shield assets from creditors, but that's beyond the scope of this short presentation. There is no need for a revocable living trust to keep separate records or bank accounts if the settlor is the trustee. So why set up a revocable living trust? The main reason that you set up a revocable living trust is that the assets that you contribute to the revocable living trust avoid the probate process when you die. Now, probate is a very expensive process and it involves attorney fees, court fees, and trust fees. There's a substantial delay in distributing assets from a probate, a minimum of 6 months, but it could go on for a year or more. Everything in the probate is public record, and it's subject to court supervision. But the assets in the revocable living trust are included in the settlor's taxable estate for estate tax purposes, but with the unified credit now in 2018 going up to 11 and some odd million per individual, or 22 million for a regular or married filing joint return, a married couple. Very few people are going to have to worry about estate tax consequences. And California has no estate tax. So do you need a will along with your revocable living trust? There's some things that a revocable living trust can't do. Both the revocable living trust and the assets and the will can distribute assets to the beneficiary upon the death of the settlor. But a will must be probated, and that includes a probate will or a pour-over will, which simply takes whatever's left in the estate and pours it into the trust. That still has to go through probate. Also, a transfer or a trust that's created by the will, called a testamentary trust, must be probated. There are some simple probate procedures in California that we'll cover in a little while that might take the bite out of the process, but they are limited to small estates. The main thing that a will does, that only a will can appoint a guardian for minor children in California. So if you have minor children, you're concerned about who's going to take care of them if you die, the will is necessary to do that. The trust can be used to impose adult management over the property of the trust left to the minor child, but not the person. There are some simplified probate procedures in California, so in certain situations, the probate process isn't overly painful. You can file a spousal property petition with the probate court and transfer all of your assets to your spouse or registered domestic partner. The transfer must be approved by the probate court, but it's a simple and much faster process. For small estates, a person entitled to receive by the will can file an affidavit with the person holding the assets, stating that person is entitled to the asset holder, and you also provide a death certificate. No court intervention is required to do this, but there's some limits on the size of the estate. $150,000 probate estate with a 40-day waiting period before you can use this process. And in the case of real estate, the equity in the property is limited to $50,000, and there's a 6-month waiting period. There's also what's called a simplified probate process, which is a probate but not a full probate, and that's for estates up to $150,000. There are other probate avoidance devices besides revocable living trusts. Certain types of ownership of property. The method of ownership takes it out of probate. Joint tenancy with right of survivorship. And this is a common way that you would own real estate. That property passes to the surviving joint tenant outside of probate. The new form in California is community property with rights of survivorship. Community property has a few income tax advantages over joint tenancy for a spouse that receives property. And now you can pass that property with rights of survivorship if it's going to go 100% to the other spouse. You can establish pay on death accounts for bank accounts, security accounts, and the like simply by filling out a form and telling who the money goes to on your death. For real property and vehicles that are titled, a transfer on death or TOD beneficiary can be set up with the DMV or whoever's are recorded, or whoever else holds title to titled assets. Of course, life insurance policies, security accounts, and the like, you can file a named beneficiary with the account holder, and the transfer will take place outside of probate. There are some reasons you might not want to avoid probate. If you have substantial credit problems, probate limits the claims period where a creditor can assert his claim against the assets. After that period of time, the assets pass free and clear to the beneficiary. If you have no one to oversee the estate after your death, a probate might make more sense. Excuse me. If you own little property, it might be cheaper just to simply use the probate process, especially the streamlined methods, and avoid the attorney and trustee fees in setting up a trust. If you are involved in a divorce proceeding, California law prohibits spousal transfers to trust during the divorce proceeding. Now, a couple can set up one living trust that covers both of their properties, and it can cover both the separate property of each individual spouse and the community property of both spouses. And this also applies to unmarried couples. Each spouse has the power to name the beneficiaries of his or her share of the property contributed, and when one spouse dies, this trust splits in half into two separate trusts. Trust one is the surviving spouse's share of the trust assets, and trust two is the deceased spouse's share of trust assets that's distributed to his beneficiaries, which may or may not be one of the spouse. So there's two all-encompassing steps in preparing a living trust. First of all, you have to prepare the trust document. There's no standard form for doing this, but it must define the trust. It must declare that the trust is being established and the property is being transferred to the trust. It must name the trustees, the beneficiary, and usually includes a list of on one or more schedules of the property that's going to be contained within the trust. And it also must contain the signature of the settlor. Now, that signature in California doesn't have to be notarized, but it's recommended that you have it notarized. The second step is actually physically transferring the property to the trust. And you do that by putting the trust into the name of the trustee. For example, Joe Jones as trustee for Jane's Living Trust. The trust is not effective without any assets. It cannot exist without assets. On death of the settlor, the trust only includes the assets that transferred pre-death. Any assets owned outside of the trust are subject to probate, including any assets that pour into the trust by the pour over will provision go through probate. When you have assets with title documents, for example, real property and the like, they can, or without title documents, and this would be all other property, you can just list them on Schedule A of the trust document, or you can do a separate notice of assignment and execute it. Now, on assets with title documents, and these are real property, bank accounts, security accounts, vehicles, business interests, there's some evidence of ownership of these trusts, of these assets. They transfer must be registered in the name of the transfer and of the trustee. And in the case of real estate, you also need to file a preliminary change of ownership report with the county. But usually the county does not reassess for property tax purposes, simply because you transferred the assets to the trust. Now, if you're putting your home into trust, there's no loss of tax benefits to you with the trust owning the property instead of you individually. The non-recognition of gain rules for the sale of a principal residence still apply. Most counties don't treat the transfer to a trust as an event triggering the increase in property tax basis. There's no loss of the homeowner's exemption. Your mortgage cannot be legally called simply by contributing the house to a revocable living trust. Your insurance policy will still cover your trust. And in most cases, for trusts, title insurance issued after May 18th, 2014, the title insurance will automatically cover that with the asset or your home when it's transferred to a revocable living trust. If you have a title policy that's earlier than that, you're probably going to want to contact the title insurance company and get an endorsement, which is usually free or very little cost. So what happens when the settlor dies? At that point in time, the trust becomes irrevocable. The successor trustee must file a trust tax return for post-death income received, and the successor trustee is responsible for notifying the beneficiaries, collecting and distributing the assets, accounting for the assets, and closing down the trust according to its terms. Now, it's important that you keep your living trust up to date, especially where you acquire property after you've established the trust. If you do that, it won't be subject to the trust terms. And again, a pour over will, which usually is part of the estate planning process, those assets may transfer to the trust, but that action happens in probate. You need to review your living trust when there's major life changes, for example, the birth of a child, marriage, divorce, etc. And there are some situations where moving to another state can affect your trust arrangement. Trusts remain legal in all states, but community property treatment in some other states might not treat the property the same. Once a trust is established and it's revocable, it can be amended or restated at the will of the settler. A restatement is technically just a continuation of the old trust restating its terms. You do a restatement so you don't have to retitle property in the name of a new trust. The old name is just used for the new trust. You can revoke a living trust at any time as long as you have capacity and before your death, and it's done by just sending a signed document and presenting it to the trustee. And the revocable living trust is then revoked and everything goes back to the way it was. So in conclusion, if you need more information about it, visit my website at www.barryweberlaw.com or send me an email. The email's on the screen. I'd be happy to schedule an introductory consultation in person or by phone. Thank you for listening to my webinar.